Hey guys, it's Melanie. If you notice what looks like fog on my glasses lens, that is in fact fog from how goddamn humid it is here today. I haven't put on any makeup, I haven't showered yet today because I still have to go clean out my car in what is somehow like 150% humidity. But I have to say something about the COCKYGATE hearing. Today was the hearing day, and we have just gotten some updates about it from a journalist called Una Park. I will link to her Twitter in the description. She made it there and tweeted a ton of information, which is so helpful. I technically could have gone. I think it was in New York. It's like a 3-hour drive for me. Wasn't gonna happen. So first of all, to kind of edify a little bit and clarify, this hearing strictly was not about the trademark. It was about the motion that Felina Hopkins' attorney brought forward to try and get the federal courts to step in and supersede the trademark office, basically using their jurisdiction to dismiss Kevin Knoopers. One of these days I'll figure out how to actually pronounce his name. It wouldn't be that hard, I'm just lazy. To dismiss his petition to cancel the trademark and not let the trademark office actually do their administrative process and figure out whether they felt it was valid or not. And also the restraining order against Tara Crescent and Jennifer Watson to prevent them from publishing any further books that infringe on the trademark. So the judge's sort of statements and decisions today don't have any specific like impact on the trademark itself, because that is still in administrative process with the trademark office. The courts have not, as it happens. That was the purpose of this hearing, basically, was to kind of determine if they felt this was a strong enough case for them to step in. And shockingly enough, it's not shocking, the judge seems to have decided that is not the case. He does not need to step in. This is typically what happens when someone tries to circumvent a process that already exists to mediate something. Judges do not want to be called in to mediate an issue that hasn't gotten to that point yet. It's very common. If you've had a lot of experience, you know, dealing with the legal system, you know this. Judges always encourage people to take every possible avenue they can to mediate outside of the courtroom. The courtroom is supposed to be the very last resort, right? So they don't particularly like being dragged in like this when something is still in very early administrative process, which it is. It hasn't been that long since Kevin filed his petition to cancel. So, according to Una's tweet thread here, the judge denied the TRO, that's the temporary restraining order. So I believe, my understanding is that means Tara can continue to publish whatever the hell she wants, and Jennifer Watson can continue promoting whatever the hell she wants, because she's not an author or a publisher, she's a publicist. She has nothing to do with this. So the judge did comment a bit on the trademark, but again, to be clear, this hearing was not about like the actual validity of the trademark. It's an issue that came up, but the judge isn't taking any steps to actually like step in and cancel it, because again, the trademark office is still doing their stuff with it. The judge is not stepping in at this point. But the judge did give their opinion. I don't want to I've been saying he. I don't actually know if it's a he. I'm trying to see if you know, it said specifically. I don't want to misgender the judge. But the judge apparently said that the cocky trademark seemed weak. And it was not clear that the word cocky was in any way indicating a series, but was rather a description. And descriptive terms generally within an industry are not allowed to be trademarked. This is something that a commenter brought up on one of my previous videos, and I don't remember his name. I will look it up. Wrong browser. A commenter mentioned that I was kind of harping on the fact that cocky is a word, it's a descriptive word, and for that reason, it really shouldn't be allowed to be trademarked. And he pointed out that it is possible to, in fact, trademark, you know, single words, and it happens. And he gave the example of Apple, which is the classic example people use. Tommy Bavaka, I don't know. We've established I'm homeschooled, I don't know how to pronounce anything. So he pointed out that yes, you can trademark common words. That is true, you can. In the case of Apple, the Apple trademark is a strong trademark because the word Apple is in no way descriptive of the products that they make. So for them to establish exclusive use of that word does not in any way, you know, infringe on their competitors' ability to do their business. And that's the issue here. You're not allowed, like if Apple wanted to trademark the word phone, which is also a common word, that would be an issue now, because then their competitors wouldn't be able to advertise or describe their products accurately. So a trademark for a common word, and this has been, there's a chart going around Twitter. A lot of the people involved in COCKYGATE have retweeted it. I believe Courtney Milan retweeted it. Not that she's involved, but you know what I mean. People that have been, you know, commenting on it, and you know what I mean. Basically, the chart saying that the more common or, you know, simple a term is that you're trying to trademark, the more the standards apply of you have to make sure that it's not a word that you're trying to gain exclusive use of that would be unfair to your competitors to block them from using this word. And so that's the question with cocky. It's not quite as clear cut as, say, a phone company, a company that makes phones trying to, sorry, like I said, it's so unbelievably goddamn humid in here. It's not quite the same as a company trying to trademark, a phone company trying to trademark the word phone. That's clearly not okay. What's less clear is cocky common enough in romance novels that it should be basically thrown out as a trademark because no one should have exclusive rights to it. Pretty clearly on the face of it, most of us kind of look at it and go, yeah, no, that doesn't make any sense for someone to trademark that word. And it sounds like this particular judge, who again was not making any kind of final decisions on the trademark, but commented on it because it's part of this case, the judge agreed, basically. But it is more complicated because we're talking about books, which sources tell me are in fact made entirely up of words. So when you talk about trademarking a word as an author, it's a little different than some industries where things are a bit more clear-cut. We're talking about, you know, descriptions, and it gets a little more complicated, but it's still fairly clear, to me at least. So, back to Unipark's Twitter thread here, and let's see. So, much of the hearing discussed what cocky represented, contents of the book, or an adjective for the title. But even if used for the title, the word wasn't strong enough to indicate a specific series. The plaintiff argued that cocky in romance genre was synonymous to Hopkins books. Again, the plaintiff in this case is Hopkins Attorneys. Something that has been mentioned a few times, by the way, on social media is that Hopkins wasn't even in attendance. That's normal. In these preliminary hearings, typically, oftentimes it's just attorneys there. That's very normal. I wouldn't pass any judgments on her based on solely on that fact. Very little typically tends to happen. at these hearings, and in fact I think attorneys generally prefer to be there by themselves because it keeps anyone from appearing unprofessional in front of the judge or having these outbursts or whatever. I'm not saying that Fleet Hopkins would do that. I'm just saying that is something, sometimes people get really emotional, and these hearings are so preliminary and nothing happens. You know, it's just discussions. That's all it is. So, you know, they can just go over the transcript with their attorneys later. That's a very typical thing. I was involved in a legal situation recently where I showed up to like a preliminary hearing and the other side just sent their attorney. That's completely normal. That's what they do. The only reason I was there was because I don't have an attorney. I was, at the time, going in alone. Had I hired an attorney, I absolutely would have sent them in my place. Nobody wants to go to court if they don't have to. It is incredibly boring. So, yeah, so they discussed, and Cocktails, Watson's lawyer said the Cocktails anthology was published as a parody of COCKYGATE. And parody, of course, there's a few things here. Parody argument is always you know, something that you want to bring in when it applies. It doesn't always apply, but I think in this case it's pretty clear that that's the situation. But also, it's also pretty clear that it's pretty clear that regardless, the word cocktails is not an infringement of a trademark for the Cocky series, which is what the trademark is. So it sounds like the judge was you know, didn't feel the need to take any action to prevent you know, people from publishing and promoting the Cocktails anthology because, again, it's a parody, and even if it wasn't, it wouldn't infringe on the trademark. Most likely. The plaintiff, again, remember that's Hopkins' side, wanted the authors' names to be revealed, but the defendant referred to Roger versus Grimaldi. You know, says, I honestly can't recall the specifics because of the jargon, but no names were revealed at the hearing. So, apparently there is a precedent, Roger versus Grimaldi, so you can look that up if you feel like reading through some legal briefs. There is some kind of precedent for not revealing people's real names when they do business under a pseudonym, which would be cool. I didn't even know, honestly, that was an option, because this isn't the first, you know, major lawsuit we've seen in the publishing industry, and typically people's real names do come out, and all their pen names come out. I don't know if everyone remembers the Alora's Cave lawsuit with Dear Author, but yeah, that was like a big deal, as real names came out and pen names were all connected together, and that was a big deal. But, so, there was something else I wanted to talk about that I have not had the chance to talk about yet. And that is the comments, and now I'm trying to find them because it's been a few days. Things happen so damn quickly in this COCKYGATE situation. Here it is. So this is something that happened a couple days ago, and I was so thrilled, and I thought I was going to make a video about it right away, but I ended up not getting to it because so many other things happened. So there's been a lot of attorneys online that have commented on this case, and it's always really awesome. But this one in particular was great because his name is Matt Marcotte. That's how I'm guessing it's pronounced. At Matt Marcotte, that's M-A-R-C-O-T-T-E, and I will link to him in the description. So he is not just another attorney commenting on this, you know, from the outside looking in. This guy was one of the people who litigated a case for an intellectual property trademark dispute called Rhodes versus Avon. This case, without going into a whole thing, had to do with a trademark dispute, and it was an instance where the court did step in and circumvent the administrative process of the trademark office. As mentioned before, that was what Hopkins Attorney was trying to petition the court to do, basically, in this case. And that's what the hearing was for today. And the judge is doesn't seem to be taking any action towards anything at this point. They're having a motion for discovery, I believe, on September 14th. And until then, nothing's going to happen court-wise unless somebody files a new thing. So, Matt Marcotte was one of the lawyers who litigated a case that is repeatedly cited for precedent. Excuse me. Oh my god. This humidity is killing me, you guys. Killing me. And my AC is blasting. Anyway, I've had a lot of coffee, alright? Just have some mercy on me. So Rhodes versus Avon is repeatedly cited for precedent in the brief that Hopkins Attorney filed. Basically saying, you guys stepped in before on a trademark issue without waiting for the trademark office to deal with it administratively. You need to do it again in this case. And this guy, Matt Marcotte, was actually one of the people who litigated it, and he says, as a lawyer who litigated one of the cases repeatedly cited in the COCKYGATE motion for PI, Rhodes versus Avon, it misstates the case badly. In Rhodes claimed that Avon's counsel had threatened him with a lawsuit during settlement negotiations. The Ninth Circuit found that was sufficient to support a declaratory judgment claim of non-infringement. I'll add an additional thing. The brief completely fails to address irreparable harm, and one of the other cases cited, where I was also counsel, notes that presumption isn't enough anymore. So, he is basically saying, and I will add this disclaimer, I speak neither for my former firm or my current employer on this topic. Views are purely my own. So, basically he's saying the landmark, the most important case that Hopkins Attorney cited in his brief that the hearing was for today, he's completely misrepresenting it and its relevance to this. So it's no surprise that the judge was like, no, I'm not granting this TRO, I'm not stepping in on this, because the precedent for it was complete BS. And Matt also said he put forward he's like, this is a rough draft of how I would open a brief opposing the COCKYGATE motion. Plaintiff's motion seeks to have the court act in two ways. First, plaintiffs seek an injunction barring publication of a romance anthology entitled Cocktails, the anthology critical of plaintiff's activities, claiming that such an anthology would infringe the registered trademark Cocky for romance novels. Even accepting the validity of plaintiff's purported Cocky mark, plaintiffs have not met the heavy burden needed to obtain a preliminary injunction against publication of this anthology. Second, plaintiff appears to seek a preliminary injunction, issuing a declaratory... I'm really struggling with that one. A declaratory judgment that the Cocky trademark is valid, and directing the Trademark Trial and Appeal Board to dismiss a pending petition to cancel plaintiff's registration of the purported Cocky trademark. There is no ripe question warranting a declaratory judgment here. Defendants have taken no action to threaten plaintiffs apart from filing a TTAB proceeding. Even if it were appropriate for this court to exercise judgment over the declaratory judgment claim, plaintiff cites no authority that supports issuing a declaratory judgment at the preliminary injunction stage. Plaintiff's motion for preliminary injunction should be denied in its entirety. I love this because even though this is just, remember, this is a guy who litigated a different case years ago that was cited as precedent in Hopkins' brief for the, injunctions and such that were requested and were dealt with at the hearing today. I really like it because it summarizes everything really nicely, and it helped me understand what was happening here. That basically, they are requesting a bunch of things to be done without any clear justification why this is something that the court should be doing at this stage, because they have not met the, quote, heavy burden. And I'm sure that is a legal term, because the law has so many great, specific terms like that, like attractive nuisance, heavy burden. I love those legal terms. They're so fun. So that's a pretty cool thing, and I really liked it. But my actual favorite part of this Twitter thread is people started popping in with questions and comments, and Matt started dropping some really interesting facts. One of which is the attorney who filed this brief is a personal injury attorney. You know those guys. They're the ones that run the ads. You know, I'm the Texas Hammerer. They must be hammered and hammered until they see the light. I think everyone's seen that one. It was like a viral, you know, ad about the woman who got $140,000 for a collapsed lung. So I don't mean to imply they're all like super shady or anything, but they specialize in a very different kind of law. And according to what Matt is saying here, trademark litigation, this is an actual quote, trademark litigation is a whole different ballgame. And someone who I believe is an author responded, would research not be his friend in this instance? AJ Spedding is her name. And Matt responds, it would. But trademark law in federal is a completely different animal than state court personal injury cases. The sort of writing you see there is quite common in state court, not so much in federal. He's referring to the style and tone of the brief that Hopkins Attorney filed. A lot of people pointed out the language was very flowery and there was like a lot of typos and like weird mistakes that his own client's name was misspelled. It was like it was a mess. And Matt's saying that's not that uncommon in state court. And the flowery language also, the term that AJ Spedding used was emotive, and Matt agreed with that. I'm deciding to call it flowery, but I think it's basically the same thing. That's something you see in personal injury cases, which again are litigated in state court. This is federal court, and as he says, it's a completely different animal, and it is quite clear, he's implying from this, that this attorney that Hopkins has retained does not have a lot of experience working with federal courts. Why would he? He does personal injury cases. He doesn't deal in federal court. And it's quite clear from the way he wrote this brief, which I love. First of all, the fact that she hired someone to do this who has no experience whatsoever doing this. When someone hires an attorney that isn't in the specialty that they need, it's something that you would do if you felt your case was so strong that it doesn't even matter. You don't even have to play the game correctly. You just need someone to make sure all the I's are dots and the T's are crossed. Because any lawyer can file a brief that is technically correct in any context. You know, that is something that they learn how to do in law school. It's just a matter of making sure everything is formatted correctly and, you know, you've got all your ducks in a row. But the softer skills of knowing, like, the style and tone that's expected and the level of, you know, accuracy in terms of things like typos that's expected, that's a little more finesse. That's something that you need a specialist for. And Hopkins appears to have decided she doesn't need someone who is a specialist in litigating trademark cases because she went with a personal injury attorney. Either that or she couldn't find a trademark attorney that was willing to litigate this for her. That is a possibility. We don't know. She had an IP attorney. I know this is confusing because we're talking IP and PI. PI is personal injury, IP is intellectual property. They're two completely different things despite being, you know, anagrams of each other. One of them is the other one flipped. Whatever. So that alone makes it confusing, but they are completely different areas of law. She had one originally, an intellectual property person who actually deals with trademarks. It's unclear what happened there, but that is not the person that she used to file this brief that led to the hearing today. So Matt also commented on two important nuances about the actual trademark issue. One, I'm not convinced she's ever actually used cocky in a trademark sense, which would be necessary to create rights. The publication of a single book with a word in its title will probably not be enough. Of course, there's more than one book, but that's an interesting thing regardless. Two, the failure to act against purported infringers promptly seriously undercuts any argument for an injunction against them. So this is a thing. And this is why, by the way, you should, excuse me, this is why you should never ever believe when someone gets a trademark and then claims they're not going to enforce it, because it literally doesn't work that way. You can't have a trademark and not enforce it. It will be taken away from you. So this is part of the issue. The fact that she allowed people to sit on other books that they had published with Cocky in the title and didn't do anything about it can be used against her in the argument for her to have this trademark. And he goes into a little more detail about the Rhodes versus Avon thing. Sawyer Bennett pops in and says, as a retired lawyer and one of the cocktail authors, I'm intrigued. Can you tell me more about how he misstated Rhodes? And Matt says, sure. At the simplest level, Rhodes is about the opposite situation, where a trademark owner threatens a registrant with litigation. The court found a declaratory judgment action was appropriate, and also it was a Ninth Circuit law. And while I haven't looked recently, I believe the Second Circuit's law looks less favorably on DJ actions than the Ninth's does. DJ here is short for declaratory judgment, I assume. And also, he says, and for what it's worth, even assuming Cocky is a valid mark for romance novels and the plaintiff owns the rights to it, I don't see how the use of cocktails for an anthology would infringe on that mark. Because cocktails is, this is me speaking now, cocktails demonstrably is a different word than cocky. Quite different. They mean totally different things. They're not even related. So, yeah. I know there was something else in here that was interesting, but again, it's been like 3 days, which is 1,000 years in terms of this case, because things are happening so quickly. He clarifies that yes, the court does have jurisdiction. There's authority permitting the court to step in and overtake a trademark process that the trademark office is still dealing with, but he says, I don't think that applies here. And yes, let's see. Tipper Dalton said, yeah, it's just not surprising the filing is full of typos, not exactly stellar legal work, referring to the fact that, you know, the attorney who did this clearly, you know, yeah, what Matt said. And, yeah. Kinsey Holly said, I try not to be a big law snob, but PI attorneys who file shoddy work like this make it easy to be one. Wonder why the firm who handled the TM filings aren't representing her here. And Matt responds, dollar sign would be a good guess. I'm actually not sure what he means by that. Oh, because she ran out of money, maybe, is what he's saying. I don't know. I don't want to speculate. I don't actually understand, because, I don't know if he's saying... That answer would make sense if someone was asking why would someone represent her, but they seem to be asking why wouldn't someone represent her. So, I'm assuming he's implying that she isn't going to pay them for it. So yeah, I really, really liked this thread a lot, and even though it's not quite as fascinating, because now we actually know the outcome of the hearing, and this came out a few days before the hearing and helped shed some light on how it would probably go, I'm still really glad that he shared all this information, because he was one of the litigators for such an important, you know, case that was cited so much in the brief. And he was able to give that insight of, like, this is not even remotely what this was actually about. And all the shade that he threw at the personal injury attorney who filed the brief was really funny to me, and I enjoyed it. I think that's about it. I need to go clean out my freaking car. Pray for me. I'm gonna die out there. It's so humid. I can't deal with it. I know I'm constantly bitching about this. You don't understand. Boston doesn't have a reputation for being that humid, but it is so humid. The only more humid place I've ever been to in my life is Atlanta. And that was bad. This is almost as bad. So, pray for me. I'm literally going to take an entire roll of paper towels out there to mop my brow with. I have that you know, excessive sweating disorder, and it mostly is just from the neck up, which is great because you cannot hide the fact that you're sweating from your head. Like, there is no way to conceal it. You just can't. Your hair gets wet, like, everyone can tell. And it is one of those amazing burdens that I bear as just part of living as me. So, yeah. Now you know about my sweating habits, and you know, hopefully a little more about COCKYGATE. So, yeah. I'll talk to you guys soon. Bye-bye!